If a law firm isn't willing and able to try a case, then they're not the law firm that a carrier should be using. We feel comfortable and confident with our investigations that we dare the defendants to try these cases. Now, don't get me wrong, a settled case is a good case, and everyone wants to get the certainty of a settlement. But you need to be able to look those defendants in the eye with absolute certainty and make them believe that you're willing to try this case.
Having so many trial attorneys at this office that have actually tried these cases, we have developed processes and procedures along the way that ensure that your case is being prepared not just for settlement, but for complete and full-blown litigation if necessary. That, in and of itself, allows us to really posture your case for settlement. It increases your settlement value just because the defense lawyers, the product manufacturers, whoever may be on the other side, knows that we're ready to go anytime.
We approach every case from day one as if it's going to try. We feel if you don't do that, you're already behind the eight ball, so to speak. We look at every case and we start investigating every case as if it's going to try. When we start litigating every case, from interrogatories to depositions, we take the depositions with the belief that the case will ultimately go to trial.
We have a lot of clients who are very demanding about how we present trials. They'll want to do mock juries. They'll want to see what our presentation is going to look like. They'll ask me, what is your demonstrative evidence? Are you using any videos? Are you using any physical evidence? How are you going to present it? They'll want to hear the arguments ahead of time, and they'll give us feedback about how things work or don't work. And they'll have input as to, okay, we think you want to do something different here. We want you to try this. It can be very useful.
After you've tried a subrogation case and actually can see the issues that play out in front of a jury, you have a better understanding of what to look for and how to set up your case through discovery. If you never see how it all plays out in the end, in the final cut and the final edits, you really don't know what issues you're looking for and what makes a real difference in front of a jury.
If the number isn't sufficient and the risk-benefit analysis calls for a case to go to trial, then it should go to trial. And that type of analysis will ultimately result in better recoveries and more increased recoveries at trial and prior to trial.